I rise to speak on the Fair Work Amendment Bill 2014. The Prime Minister used to say that WorkChoices was dead, buried and cremated, but in reality this bill represents a return to WorkChoices. It's not about giving people more flexibility, it's about giving bad employers even more power over vulnerable people who are already in a worse position because of the unfair federal budget. Most of us would think that an agreement applying in the workforce involves at least two people, at least two parties. But under this legislation, an employer is now going to be able to agree with themselves about what legislation and minimum conditions would apply in their workplace. The provision about so-called greenfields agreements says that if a business is about to start a new project that might be, say, to dig up all the minerals that all Australians own, because we only get to dig them up and sell them off once, and if they want to negotiate an agreement for wages and conditions over the course of that project when it gets up and running, all an employer needs to do is to put a substandard agreement on the table and say, here's what I want. If 3 months later there's been no agreement, it's able to go off to the Fair Work Commission and get the agreement ratified. They do not even need another party to the agreement. They just have to decide it themselves. I'm not at all confident that a wealthy miner is actually going to look after its workers when it doesn't have to. It's going to pay the least it possibly can, and that is what this legislation allows them to do. We've also seen this obsession that's reflected in this bill from the government about employees having access to their union representatives at reasonable times. In many workplaces, often the only way workers will find out about what their entitlements is from a union representative who comes in and tells them, no, actually there are laws to protect you and you are entitled to be paid properly as a member of the Australian community. Yet what we see here in this legislation is a winding back of these provisions that will allow someone to come in and give that explanation. What we know is that what some unscrupulous employers do at the moment, or have been doing in the past, is to say, sure, you low-paid worker, you can find out what your minimum legal rights are, but I'll tell you what I'll do. I'll put the union representative, when they come during your lunch break, in a room next to my office, and I'll just sit there with a clipboard making a note of every worker who comes in to get advice about what their minimum conditions are. And we all know what can then happen to those workers. Currently, the law says you cannot do that. You must strike the right balance between not disrupting the workplace and allowing people to find out what their minimum entitlements are. That is abolished under this bill. When you think about this from the perspective of a vulnerable worker who may not have English as their first language, how are they going to find out about their rights? They simply will not. That will be the practicality of it. That is exactly what this legislation is designed to do. The bill tilts the playing field further in favour of powerful employers by allowing them to just sit there, fold their arms and say, we refuse to engage in discussions with you about an enterprise agreement. Plus, it will take away the only thing that the employees have the right to do in that situation, which is their right to industrial action. At the moment, if your boss refuses to negotiate with you, you're allowed to say, we're going to stop work meetings, or we're going to go on strike until you strike a deal with us. You would think that workers should be given the right to go to Fair Work and say, look, we just can't strike a deal. We've been trying, so why don't you decide as the independent umpire? But this bill does nothing of the sort. In fact, it does not allow them any help. It further ties their hands and allows the employer to sit there and say, I'm just not going to negotiate with you. These are just some of the measures in this bill. There are others that say if you have happened to accrue annual leave loading and other reasonable measures during your time at work, and it turns out that you get sacked before you've had the chance to take them, then don't expect to get your full entitlement paid out. You're only going to get part of it, And these are measures that you have legitimately accrued during your time working for this employer. When one looks at the other provisions, you can see that the government has gone back to the previous Fair Work review and just picked the eyes out of it, putting forward only those measures on the employer's side of the ledger, but there's nothing to balance it up on the other side. That's why the Greens will not be supporting this bill. Instead, if we get to a third reading of this bill, I'll be moving some amendments to remove these clauses of the bill and instead substitute them with other clauses that would actually benefit working people in this country. Because the Greens want to improve conditions for working people, not just to have them desperately fighting to hang on to current conditions. We will try to, absolutely. We reckon a real Fair Work bill would tilt the tables the other way to genuinely make work fairer. Our amendments, if we get to the third reading, would give workers more job security and allow workers to have flexibility that works for them, so that they can have the time off to pick up the kids, to drop them off at school, or perhaps to look after a sick grandparent. I want to actually spend some time talking about these amendments here and now, because our amendments would actually create a bill that really was a Fair Work bill, that really would provide for flexibility. A big reason that we hear the term work-life balance so much these days is because we have less balance than we should between the two, between the amount of time and effort and dedication to work as opposed to the rest of our life, our family commitments, community commitments, time for exercise, leisure, doing activities that are good for our health, including sleeping. It didn't used to be this way, and it doesn't have to be this way. The figures show that the average full-time working week in Australia is 44 hours, the longest in the developed Western world, and research shows that these sorts of working hours are impacting on our well-being with poorer health and greater use of prescription medications. It's also affecting our personal and family lives. 60% of women say they feel consistently time-pressured, and nearly half of men also feel this way. Almost half of all fathers in couple households work more than they would prefer, and 1/3 of women working full-time would also prefer to work less, even taking into account the impact that this might have on their income. If you want to talk about flexibility, then consider that on average full-time employees would like to work about 5.6 hours less per week, while part-time workers would like to work about 4 hours less than they are currently working. And in addition, we work $72 billion of unpaid overtime each year as a country. It cuts the other way too. There are many people, though according to the studies a lesser number, who would like to work more hours than they are currently working, but are unable to. In a 2010 study on the health and working conditions of approximately 78,000 working Australians concluded it may be counterproductive for employers to expect long working hours, as employees are likely to take more time off and work less efficiently. And the study also commented that there is considerable evidence of an association between work demands and poor health. There's no doubt that many good employers already recognise the benefits of providing flexible working arrangements. However, this recognition is not as widespread as it should be. The Greens want people to have more control over their time and their working arrangements. We need a better match between the hours people want to work and the hours that they actually work. And I note that the ACTU, prominent academics, Carers Victoria, government advisory bodies and many others have also advocated extending the right to request flexible working arrangements. The current legislated mechanism to request flexible working arrangements is only available to employees who have caring responsibilities for children under school age or children under 18 with a disability. Employers can refuse on reasonable business grounds, but there are no mechanisms for appeal. The mechanism is well-intentioned, but it's narrow and unenforceable. It can be strengthened, and it should be strengthened. And if we had a bill that had these measures included in it, it would be strengthened. The amendments that we're moving also reflect the Greens' view that wherever possible, enterprise bargaining and enterprise agreement should be the best mechanism for providing better industrial outcomes. Flexible working arrangements would be inserted into the list of permitted matters that be included in an agreement. And in all instances, the right to request flexible working arrangements to all employees, it would be able to be refused by the employers. And the right to request would be strengthened for those with caring responsibilities, with employers only able to refuse where there are serious countervailing business reasons. Ongoing employees must have performed a minimum of 12 months' service before the request could be made, and if an employee's request for flexible working arrangements was refused, Fair Work Australia would be empowered to hear an appeal and, where appropriate, make flexible working arrangement orders. Allowing workers to have more control over their time would be a productivity bonus for the economy. Businesses would benefit from this reform, including employers who are already promoting flexible work arrangements, so that employees can achieve a better work-life balance. Satisfied employees are likely to remain in a workplace longer, be healthier and be more productive. If people want to work different hours or work from home so that their life is better, then the law should allow it and society should encourage it, provided it doesn't unduly impact on their employee. Our amendments recognise that carers play a special role in our society. Caring for those close to us must be a central concern for our society, and it's important for the economy. People need greater control over their time, not just to look after kids, but also increasingly to look after parents and grandchildren, as well as foster children, people with disabilities, people with extended illnesses. The list goes on and on. For this reason, our amendments define carer simply as an employee who has responsibility for the care of another person. In addition, as I've referred to, the bill raises the threshold test to serious countervailing business reasons before employees could refuse a request for flexible working arrangements. There are more women working more hours in paid employment, but there's still the unpaid caring to do. With caring still done predominantly by women, there's a growing double burden on women and their families. And if we're serious about supporting women returning to work after having had kids, we can and should do many things, not only expanding accessibility, quality and affordability of childcare, but also giving a legally enforceable right to flexible working arrangements. As I've referred to, the provisions do not remove the capacity for managerial decisions to be made regarding working hours and working arrangements. If there were legitimate business reasons against a request, they would be able to be declined. These measures aren't radical or unprecedented. A number of countries have various types of legislative mechanisms for people to request flexible working arrangements, and a serious countervailing business reasons test has been used in the Netherlands since the year 2000. And a review of flexible working arrangement laws in Germany, the Netherlands and the UK showed that a number of valuable lessons had been learned and a number of myths dispersed regarding the laws. There was a reasonable but manageable level of requests. The Netherlands had the highest level of requests, with 14% of employees, while the UK had only 3.5% and Germany recorded less than 1%. But significantly, the majority of the requests in each country were acceptable to employers, and costs were not a major problem, with implementation and sometimes even resulted in savings. In addition, very few requests ended up in dispute. In the Netherlands and Germany, fewer than 30 requests per country resulted in court action in the first 2 years of the law. The overseas experience suggests that being obliged to provide flexible work for employees may in fact help companies by ensuring that they examine alternative models that they may not have considered previously. If our amendments were passed, it would not undermine those very important industries and sectors like firefighters, and there may be many others as well, where control over working time is necessary to ensure that there's not industrial arguments between people working differing hours side by side in environments where harmony and consistency and equality of payments and arrangements are necessary. As I said, it wouldn't override management prerogative. Our amendments would help to drive positive cultural change in relation to flexible working arrangements by providing a clear framework and criteria for requests, and importantly, would begin to remove the stigma of fathers and mothers, and indeed anyone who's got to care for another person, anyone who wants to have more control over their life, requesting that change. We urge the Senate to reject this bill as it currently stands. But if it got to the third reading stage, our amendments would radically change the bill, and we would want to see them supported to truly give workers the flexibility and work conditions that they deserve.